To our first calendar year event of the season, brought to you by the Federalist Society. I'd like to thank Senator Froman and Secretary Sanders for coming, as well as all of you. I know schedules are hectic, and I really appreciate that you guys took the time to hear this important debate concerning what level of scrutiny should be applied in gun law cases. So I hope you guys were able to read some bios online. I don't, because of the time limits that we have. I'll refer you to those. And without further ado, Senator Froman, thank you.
Hi. And first of all, I just want to thank Alex Pfeiffer and the Federalist Society for inviting me back. I was here last year, and it's really a great law school. You have beautiful weather for me. I can't believe how booming everything is. I know I'm taking up my time that I have to talk, but I want to compliment you on a beautiful city, and hope I get invited back again. I want to talk a little bit about the level of scrutiny that should be applied to Second Amendment cases. And we have to start with the Heller case, District of Columbia versus Heller, which was decided in 2008. And the whole point of that case was the determination by a 5-4 decision of the U.S. Supreme Court that the Second Amendment does indeed guarantee an individual right to keep and bear private arms for people who are not connected with the state-sponsored militia. In other words, you don't have to have the permission of the government to have a gun. 2 years later, in McDonald versus City of Chicago, they took that principle and they applied it to the states. So I always ask people, who was here last year and heard me speak? Anybody? A couple of people. So you should know the answer to this question. Why was the Heller case filed in the District of Columbia, which is very, very anti-gun? Why don't you file a case like that in Texas or Idaho or some state that's very pro-gun? Why D.C.? Anybody know? Come on. I asked the same question and got it answered last year. All right, what's different about D.C.?
It's not a state.
It's not a state. Okay, what does that mean? There's no state law to get in the way. The federal constitution applies directly in the District of Columbia to assess whether or not that law in the District of Columbia, the ordinance, if you will, was constitutionally valid or not. Then they take the case to Chicago, which has a pretty much identical gun ban, and they see whether or not that federal law relating to the Second Amendment, that it protects individual rights, whether or not that applies to the states. And again, 5-4 decision, U.S. Supreme Court says, yes, it does. That's the law of the land as of 2008, 2010. So I want to talk about the standard of review. Does anybody know what standard of review was applied in the Heller case or the McDonald case? There was no standard of review. By the way, how many people are taking or have taken constitutional law? Do you talk about Heller and McDonald? Thank you, Professor. Do you talk about Heller and McDonald in those classes? No? Oh, not yet? Okay. It is a great case McDonald especially is a great case to teach about the doctrine of incorporation. In other words, incorporating the rights guaranteed by the Bill of Rights as against the federal government and as against the states. In other words, the Bill of Rights was intended to limit the powers of the federal government, to guarantee individual rights so that the federal government couldn't take them away if you were in a minority. And without the Bill of Rights, the Constitution never would have been ratified. We'd probably all be speaking with English accents here today. So what's important about McDonald is that they had to incorporate that decision in Heller as against the states, because the Bill of Rights is only supposed to apply to the federal government. It's not supposed to apply to state governments. And most of the Bill of Rights has been incorporated in the states, but not all. That's your homework, to figure out which ones in the Bill of Rights are incorporated. We all know the First Amendment has, but basically there's some rights in the Bill of Rights that have never been incorporated to the states. Okay, I better keep going faster here. Strict scrutiny is the proper standard of review for laws that substantially burden self-defense in the home. That's the lesson we learned from the Heller case. What do we mean by standard of review? When you determine whether or not a law is constitutional, you have to look at what standard to apply. Is it a good idea? Did the governor sign it? Do the police want it? What if you have an enumerated right like you do in the Second Amendment? spelled out there in black and white, well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. There are many rights that are not enumerated in the Constitution, which have been upheld by the U.S. Supreme Court. But this is an enumerated right, it's spelled out specifically. And that right is entitled to strict scrutiny, at least to the extent to which it applies to total bans on ordinary firearms that are kept in the home or borne by individuals. The question is, how far outside the home can you go for self-defense? The Heller case basically said that the right to keep ordinary commonplace operable handgun in the house is protected by the Second Amendment. Okay, my question was, what level applied in Heller? They didn't even talk about the standard to be applied. They just said under any scrutiny standard, the total ban on the possession of an ordinary handgun in the home of self-defense was unconstitutional. So the Seventh Circuit, Moore versus Madigan, after that, held that a ban on bearing arms in public, carrying, okay, understand the right to keep and bear arms. Keep means you own it, you possess it, it's in your home, you're not necessarily walking around with it. Bear is carry it. Carry it in the home, carry it outside the home. But Moore versus Madigan, which was a Seventh Circuit case, held that the total ban on bearing arms in public, so where no carry permits were allowed, was also unconstitutional. And basically under Heller and McDonald, any blanket ban of ordinary, commonly used, popular firearms is going to be held invalid under the strict scrutiny standard. Now, arms that aren't bearable, I always get asked, I used to get asked, not anymore, the story, oh, what about an atomic weapon? Is that a weapon covered by the Second Amendment? No, because you probably can't bear it. Things like, cannon, things like, although cannons aren't necessarily firearms, they don't have rifle barrels, but, or I'm sorry, because they're muzzle loaded. So arms that aren't bearable aren't necessarily protected. The Heller case had an exception for arms that were exceptionally dangerous or unusual. Query what that means. Maybe it means machine guns, maybe it means something else. But it was kind of left open. That was a little opening that got left. Justice Scalia wrote that opinion in Heller, and there were a lot of little, what I would call acknowledgments that, we don't allow felons to have firearms, and those bans are fine. And we don't allow people who are mentally defective and dangerous to have firearms, and those bans are okay. A lot of this were concessions to Justice Kennedy, who was the fifth vote. Without his vote, the case would have gone the other way. So there is more than one type of scrutiny depending upon the type of law challenge and the type of Second Amendment restriction involved. Talking about self-defense, ordinary handguns, and probably ordinary long guns as well. A total ban is clearly unconstitutional when strict scrutiny applies. You have to apply some type of heightened scrutiny if the Second Amendment right, the enumerated right, is implicated. Basically, there's three types of scrutiny. Strict scrutiny, intermediate scrutiny, and that's a big, broad range. And a lot of this law has been developed in the First Amendment context, and I think the Second Amendment cases are going to borrow from that. And then the third type of scrutiny is what's called rational basis. Rational basis is sort of like it sounds. If the sheriff tells you that his job would be easier if we had this law, that passes the rational basis test. Thank you. So what you have to do, if you're looking at a law to determine what level of scrutiny to apply, you have to ask, and this applies to law-abiding adults, okay, not children and not criminals, not people who are considered in a special category, maybe because they've been adjudicated by a court as mentally defective and dangerous to themselves or others. The question you ask is, how close does the law come to the Second Amendment core of protecting the right of self-defense? The closer it is to that right, and the closer the gun is to an ordinary, commonplace firearm that people historically own for self-defense, the more likely you're going to require strict scrutiny or some lesser level, but still high level of intermediate scrutiny. Professor Sanders, it's all yours. Thank you.
Good afternoon. I guess it's technically early evening, so happy early evening to you all. I too want to thank the organizers of this event, including Professor Sandra Froman, who's visiting us from out of town and who I hear will be visiting the University of Idaho's Moscow campus to talk about this topic. So you're sort of getting all of Idaho in on this trip. And Alex Pfeiffer and all of the members of the Federalist Society and Professor Lee for inviting me here to speak with you. I've been kind of dying to come to your building and just haven't quite gotten around to it. So I teach actually the Heller and McDonald cases in my constitutional law 2 class. And it's always a really fun discussion because I start by taking a look at it from an interpretative standpoint. Sort of what did the Supreme Court do differently in Heller and McDonald than we had seen in previous Second Amendment jurisprudence. So to give you a little bit of that, the original interpretation or what the court had done for really up until 2008, so over 200 years, 200 years, the court had really prefaced the meaning of the Second Amendment based on that first clause. So what does the Second Amendment say? A well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed. Now, setting aside all of the commas and some of the drafting issues with this particular amendment, what the court has normally said is that one's right to keep and bear arms was really contingent on their membership in some type of militia. In the court's opinion, that first clause, a well-regulated militia being necessary to the security of a free state, that's really sort of the purpose of the Second Amendment, and therefore that right to keep and bear arms is contingent on keeping a well-regulated militia. And that really hadn't been challenged very much over time. So what effectively did that mean? Many Second Amendment cases have been decided before the Heller case. Well, the court had decided that the term arms did not include pistols, Bowie knives, brass knuckles, and other weapons employed in brawls, street fights, and duels. The court said that this right to arms did not include any right to any particular bullets or blackguards or should say any weapons that are common to bullies or blackguards or desperados. And then the court has said that the right to keep and bear arms did not include any type of right to use weapons for purposes of terrorizing a community or injuring individuals or the state. So what did this mean before Heller? Well, possession and or use of a firearm or other weapon was neither an individual right nor a fundamental right. And the court had maintained that the Second Amendment did not apply against the states. Now, Heller and McDonald changes both of those propositions. Heller, of course, untangled or detached that first part of the Second Amendment that talks about the militia. The court says, well, the right to keep and bear arms is really not dependent on one's membership in any type of militia. So that's a real change in interpretation. The court also said in Heller that the Second Amendment was an individual right to keep and bear arms in cases of confrontation and self-defense in the home. So even though the court sort of broadens its interpretation of the Second Amendment, it still kind of kept it narrow with regards to when the fundamentality of the right being limited to self-defense in the home. And the court was very clear in Heller to say that the Second Amendment right to keep and bear arms was not absolute. So then 2 years later, after Heller, we have McDonald that changed the court's interpretation with regards to whether the Second Amendment right to keep and bear arms was one that applied against the states. Now, as someone who spends quite a bit of time talking and teaching and actually writing about this subject of which rights apply against the states and which don't, I have to admit that I find there are some flaws in the court's analysis in the McDonald case. Traditionally, Duncan versus Louisiana laid out a three-part framework to whether or not a right was fundamental. That those three prongs included the question of whether the right was fundamental to a principle of liberty which lies at the base of our civil and political institutions. The second question was whether the right was basic to our system of jurisprudence. And the third asks whether the right was essential to a fair trial. Now, you don't need all three, but the court usually talked about one of those three factors when it determined whether or not other rights were fundamental, such as the First Amendment, the Fourth Amendment, portions of the Fifth and Sixth and Eighth Amendments. And yet, we did not see any of that discussion in the McDonald case. Now, that does not mean to say that I disagree with the court's analysis. I think once Heller determined that the right to keep and bear arms was fundamental, then that sort of led to the conclusion that it applied against the states, because all of our rights that have been deemed to be fundamental do apply against the state. Just from an interpretative analysis, however, there were some flaws in the opinion there for me. But of course, every time the court makes a new rule, it opens a can of worms. And so we find ourselves in the post-Heller and McDonald world with more questions than answers. First of all, does the self-defense rationale only apply against the home or also in public? And if so, what are the implications of that? And what do we do about bans on firearms based on location, like schools, government buildings, churches? We see some states have passed new legislation that says that really frees up that right to keep and bear arms to allow guns in places like churches. And doing so, those states have also run against other fundamental rights issues, like the right to practice your own religion. If you're a church that does not want guns in your church, do these new laws infringe on your First Amendment right to religious belief? What do we do about other restrictions based on age, right? 5-year-olds can't go and buy guns in the same way that they can buy candy. Is 21 the age? Or what about those who are mentally ill, felons, misdemeanors, and documented and undocumented non-citizens? And then finally, what do we do about restrictions that still exist based on the type of arm? Traditionally there, we're talking about some type of firearms, but what about firearm accessories like bulletproof vests, high-capacity magazines? Other arms, you'll be surprised to know that there's case law on nunchucks and nuclear arms. Are these now sort of open for reinterpretation? What do we do about our carry permitting legislative schemes, licensing fees, waiting periods, firearms safety courses? Do requiring these type of activities infringe on one's right to keep and bear arms? And then finally, what do we do about the perception of those who keep and bear arms? One of the common controversies now is the use of excessive force in law enforcement. And many of those cases have hinged upon law enforcement's judgment that a particular individual is carrying a firearm and is dangerous. And I think we're seeing a lot of evidence that based on one's race, you could be perceived more dangerous as other people. And so how do we reconcile those perceptional issues with the right to keep and bear arms? I look forward to the rest of our discussion. Thank you.
Well, one thing Professor Sanders and I both agree upon is that Heller and McDonald really opened the doors. They generated more questions than they answered. And now states around the country and federal courts around the country are trying to answer those questions. And sometimes the answers conflict. What do you have when you have a conflict between the circuits? You have a case that might be right for cert up to the U.S. Supreme Court. But what's really interesting, the Supreme Court has refused has denied cert in every case that's gone up since then. It's addressed a major issue involving the Second Amendment. I think they're sort of tired of this issue, exhausted by this issue. It's interesting what Professor Sanders was talking about with respect to the well-regulated militia aspect of the Second Amendment and how that was the accepted understanding of what the Second Amendment meant for so many years. Nobody ever challenged that until a fellow named Don Cates, who was a liberal lawyer from the San Francisco area. He marched with Martin Luther King, and he decided that as a true liberal who believes in the Bill of Rights, that the Second Amendment really did guarantee an individual right. He started writing about this, and his law review article was basically, in the Michigan Law Review, was one of the very first law review articles in a major law review that caused people to rethink this issue and to say, wait a minute, maybe you don't have to be a member of a state-sponsored militia to have this right. And then constitutional law scholars like Sanford Levinson from the University of Texas and Akhil Amar from Yale University started writing about this topic. And what did that mean? That meant it legitimized the topic. Before that, people, decent law professors at decent law schools were not writing about this topic. It just was not discussed among scholarly in scholarly circles because it was considered to be sort of a second-class citizen of all the rights. When I went to law school many years ago, we had a constitutional law casebook that was this big. There was no mention in the entire book of the Second Amendment, except that the publishers did have the intellectual integrity to reprint the Bill of Rights in its entirety in the appendix to that book. And that was no discussion of the Second Amendment. So I commend Professor Sanders for talking about this issue in con law class, because the Heller case is really an interesting case, and because it involves, linguistic interpretation, it involves historical interpretation, it involves public policy issues, and obviously constitutional law issues. It's a great teaching tool. And then McDonald, after that, is a great teaching tool for the doctrine of incorporation. The arguments were actually made by the lawyers in the McDonald case were arguing for incorporating it under a different part of the Constitution. But the Supreme Court did what it was comfortable doing, what it had done in the past. So I will say that in 1991, which was the year that they celebrated the bicentennial of the ratification of the Bill of Rights, there was a traveling exhibit sponsored by our government, the U.S. Commission on the Bicentennial. And on the Second Amendment, they had pictures of militia troops marching. And that was the official position of the United States government as late as 1991. Professor Sanders talks about bullies, blackguards, and desperados. And I want to raise this just for a minute because it will show you how far we've come. We both cited the Second Amendment to you. Was there any mention of self-defense in the Second Amendment? No. Self-defense is not mentioned. Self-defense was not what the Second Amendment was all about when it was written. What was it about? Why was the Second Amendment written? Anybody know? It was written to protect people, the ordinary people and their states, originally starting with the 13 colonies, from an overzealous, a tyrannical federal government. People insisted that the Second Amendment be in there because they'd just broken away from England and they didn't want a monarchy. They didn't want another situation that they had fought a revolution to free themselves from. The Second Amendment, if it was intended to be controlled by the government, you can't overthrow the government if the government can tell you whether or not you can have a firearm. But today, in today's world, one of the big issues is concealed carry of handguns. Back when Professor Sanders was talking about someone who concealed a handgun was considered a bully, was considered a desperado, was considered a robber. I mean, those are the people who held up stagecoaches, and even before that, in England, they concealed their weapons. They were bad. They didn't wear their weapons or carry their weapons openly. And that was a very different point of view than we have today, where concealed carry is beginning to be thought of as polite, a polite way to arm yourself and to have your firearm with you. Thank you.
So I'd like to begin by issuing a profound apology for Professor Andrew Kim, who for some reason I referred to as Professor Lee. My apologies. Professor Froman brings up a really good idea, which is what's next for the Second Amendment. Well, as of right now, most of the circuits agree, I think all of them actually agree, that intermediate scrutiny, which asks the question of whether the regulation is substantially related to an important government interest, most circuits are agreeing that that is the standard for regulations of firearms with regards to them applying outside of the home. So much like the same-sex litigation, unless we get some circuit split, I don't see the court touching that one with a 10-foot pole. But I have thought about this a lot. Is intermediate scrutiny really the best level of scrutiny to apply to Second Amendment regulations when we're not talking about sort of the self-defense in the home? And what much of my thinking on this is that there is this tension between one's right to keep and bear arms and things like public safety, intimidation, harassment, and to which to some degree really implicates other people's feelings of safety and freedom. And this is not uncommon in jurisprudence on constitutional rights. There's always some type of tension. One of the biggest tensions I think of is the right to terminate a pregnancy. There, the court has recognized that there's a real tension there between the individual right of that potential mother and the right of that unborn fetus. And there, the court has come up with an undue burden standard, asking itself, well, whether does that regulation constitute a substantial obstacle to one's exercise of the right? That's the current standard. I wonder if maybe if the court is called upon to determine whether it will recognize sort of this tension and this duel between the Second Amendment and public safety and other people's right to feel safe, and maybe come up with some type of compromise similar to what we see in abortion jurisprudence. But what has me most excited about the Second Amendment, I have to say, is that Heller was a case that came 40 years after the last incorporation of any other right, which was the Sixth Amendment criminal jury trial clause. And maybe Heller has reopened the door to the consideration of other enumerated portions of the Bill of Rights that have not been deemed to be fundamental. Here I'm talking about the Seventh Amendment civil jury trial clause. You'll be surprised to know that that is not incorporated and does not apply against the states. Nor does the Eighth Amendment's excessive fines clause apply against states. And we're seeing a lot of controversies there with regards to civil forfeiture statutes and things like that. What about the Fifth Amendment's grand jury clause? Or the Fifth Amendment's unanimity requirement for juries and criminal trials? And then finally, what about the Third Amendment's prohibition against forcing individuals to quarter soldiers in their homes? That seems pretty important to me, and I'd like to move that one from the unincorporated to the incorporated pile so that I don't have to answer the door and start feeding and housing soldiers unless I like to. So I think that in many ways, Heller has opened a door of possibilities that seem to very much shut and close for the past 40 years. And I think that's a real positive from the court's jurisprudence. I will cede my last minute to the question and answer section.
Well, fantastic. Thank you both so much. At this time, we've got about 10 minutes. If there's any questions from you, the audience, please feel free to direct them to speakers. Thank you.
And you have to say your name.
My name is John McCrosty, and I am an alumnus of Concordia, I'm proud to say.
Congratulations.
Hey!
I would like to ask both of the speakers to address the concept of permitless carry, also known as constitutional carry, and how that fits into the Second Amendment.
Well, I think I talked a little bit about this when I talked about concealed carry being something that was disfavored in the early days of the Second Amendment because only criminals carried their guns concealed. Everybody carried guns. I mean, guns were a regular tool in everyday life in those days. And we used them to put food on the table, keep the foxes out of the hen house and whatever. And also for self-defense, but you didn't hide your gun. I think the movement, what's really interesting is you have open carry, you have concealed carry, and now you have, you know, concealed carry with permit, and now you have this movement for permitless carry. I think that there are a lot of people who feel that sort of this overarching feeling of freedom from the government. Maybe Tea Party people express it the best, that the government shouldn't be telling me what to do, especially when it comes to my constitutional rights. I think that what Professor Sanders said is true. There is an intimidation factor. I mean, I have a gun with me all the time in Arizona where I live, but I'm a lawyer in private practice, and I don't greet my clients at the door with a gun on my hip. Why? Because it would freak some of them out. And it's merely a matter of being polite to conceal your firearm. I consider it polite carry. There are some people who like to demonstrate that they're carrying a firearm to make a point. I think this is really about the particular culture in which you live and whether or not this is something that fits with the culture. And one of the reasons for concealed carry, and I've talked a lot about this year and last year about concealed carry on campus, is there are some students who are really uncomfortable with that. And when you ask people what are the pros and cons of concealed carry on campus, people always know what the pros are, but people need to talk about the cons, which are it might intimidate fellow students, it might make them worried about whether or not the person who's carrying actually has had some sort of training and knows what to do if there is an emergency situation. So I am all for, and I think that's what the Federalist Society is all about, is talking about these issues, bringing them out into the open and debating these issues.
Great question. So I'll push back a little bit on this view that in founding times that everyone sort of had the right to carry their guns, and sort of everyone's tipping their guns to each other, hello, hello, hello. Because it's pretty clear that certain segments of society did not have the right to keep and bear arms during that time. In particular, slaves. And many have written about how the Second Amendment was also in part based on a desire to keep one's human property in line. And therefore, keeping those firearms out of the hands of that property was essential. And enforcing the right of the owners to have those arms was essential to one of the most horrific things about the founding of our country. Other regulations that kept firearms out of the hands of certain immigrant populations and native populations as well. So I think we've always had a tension with regards to our perception of who gets to exercise this right and who doesn't. I'm curious about this concept of polite carry. And I would actually resist a notion that our exercise of rights are contingent on the culture in any particular community, for all types of reasons. I think if there is a right, then in many ways it makes sense that the right applies equally across the board, regardless of where you live. I haven't had any issues with our new carry policy at the University of Idaho. And for that, and I am not challenging anyone to start an issue. But I think it should be important to note that part of what I do in my classrooms involves heated discussions on a lot of different issues. Everything from discrimination and race to criminal justice. And I certainly would not want there to be a perception of a student based on the idea that they're carrying a firearm. So there I haven't quite figured out what we do about concealed versus non-concealed carrying. Part of me thinks that, hey, do it out in the open, let it be out there, let people know and have the most information about you as an individual before they decide to interact. But I wouldn't want those who carry to be marginalized and sort of stuck on one side of the room. So I think that there's a lot of thinking we have to do about that.
Next question. Mr. Warren.
Okay, I'm Chad Warren. I'm a student here at Concordia University. Last semester, we actually took a judicial writing. There were only 3 of us in the class, and this is the issue we wrote on. We took a case that was essentially, it said, a person had, a fictional state banned the right to carry a firearm for anybody outside of the home for 3 months. In that case, our entire class, the three of us, the three-judge panel, came to the idea, putting intermediate scrutiny forward, that a state could, in fact, ban everyone from carrying a firearm outside of the home under that type of scrutiny. And one of the things I found that was difficult about that was you have to first internalize how you feel about guns and that sort of thing. Even the most liberal among us came with this. Even the most conservative among us came from this, and I was more of a middle-of-the-road type of person. We all came to the same decision, using the way that the class was go out there and find it and then bring it. So I thought it was kind of an interesting thing. I'm interested in why the court is not taking you. I think you mentioned earlier this is not a circuit split. There does seem Judge Posner has a wildly different view on what D.C. Heller stands for, what McDonald stands for, the right to self-defense in the home, where it's so funny because the Second Circuit believes that carry is one thing, and the Ninth Circuit of all things has the conservative position on this. And so, I mean, if you guys could expound upon why the circuit split seems to be different on concealed carry to non-concealed carry, and why Judge Posner, of all judges, seems to have a different view on this right to self-defense, because that's what he believes it is a right to self-defense. If you guys could elaborate on that, that would be interesting for me.
Go ahead.
I don't know. Like I said, the circuits all seem to be in agreement that intermediate scrutiny is the proper level of scrutiny, and because of that, I just don't see the court taking up any case unless there is some type of circuit split. I don't see the court really dabbling in any more interpretation. I think they've sort of said, we've dropped this bomb, clean it up, circuits and district courts, and we'll just kind of see where the rubble falls. And I think that was a really interesting project you guys had. And it brings up another issue in some Mountain West state, I can't remember, it's either Colorado or Utah, has a law that a small municipality in that state has a law that requires ownership of firearms. And clearly, if challenged, that law would not be upheld. Oh, it's in Utah. So you know, it's interesting. You may find municipalities and states who sort of want to push it to get the court to sort of interpret to come back to this issue. But I don't know if they're going to bite.
So, yeah, my question, I guess, the circuit split that I found was about concealed carry, about whether someone has to have the ability, a good reason to carry. So in New York, the good reason standard is you have to put forth a legitimately good reason to have the guns. Well, in New York and California, they both have basically the same doctrine. The Ninth Circuit says, no, good reason's not good enough, and they've struck it down. New York has said they're perfectly fine, so there's that. I apologize for not being clear about the circuit split on that, and I'm wondering if
on whether intermediate scrutiny is actually met.
Yeah, exactly, because everybody's using intermediate scrutiny. That's true, but there are some periphery issues, especially when it comes to concealed carry, that are not settled. Do you believe that could come to the court at any time?
I'll give the classic law professor answer. It depends.
So we both agree that we don't think the court's going to be taking up any Second Amendment cases in the near future. And of course, remember, we may have some serious changes in the court depending upon the outcome of the presidential election. So all bets are off. Both Heller and McDonald were 5-4 decisions. So, just because Heller's the law of the land and McDonald's the law of the land doesn't mean that can't change if we have a completely different court. But, the other interesting thing, and I want to kind of emphasize this, is I agree that whenever you're talking about a regulation on firearms or components, ammunition or whatever you want to add, intermediate scrutiny is the test that all courts are using, but they're using different levels of intermediate scrutiny depending on the circuit. But when you talk about a gun ban in the home, that's still strict scrutiny every time, or anything that comes close to a gun ban. In your backyard maybe, or your front yard, once you walk across your property line. And a lot of the intersections, as you were pointing out, between rights come to play in what we call the parking lot cases, where employers would ban employees from having guns in the workplace, which everybody understands that. But when you ban employees from having their guns in their cars, in their locked, parked cars, people who can lawfully own those guns, what you in essence do is you disarm them from the time they leave home until the time they come back home. And then you prevent people from protecting themselves while, because most people do their shopping, they do run their other errands, they do their doctor's appointments, either going to and from work. And if you tell people you can't have your legally owned firearm in a locked car in the company parking lot, you're in essence disarming them, throughout the entire day. But that's an intersection between property rights and the Second Amendment. And, courts come down different ways on that. And there are cases where obviously if it's like a government facility and there's nuclear weapons involved or something, you've got it's a secure facility, it's a top secret facility, the rules are going to be a little bit different. And even in states where they've allowed people to carry concealed, they still recognize the right of private businesses, restaurants and whatever, to say, you can't bring a firearm into my business because it's not my home, but it's close to my home.
Do you have anything you'd like to add to that? All right, well, real quick, I think we have time for
Sorry.
a quick one.
Well, I was just thinking back on when they passed that concealed weapons for colleges here in Idaho. And it seems like there's a conflict here because you're saying in workplaces you can say no, but Greg Campikian, who teaches in the biology department, wrote a great editorial in the New York Times. He teaches at Boise State. And his thing, it was tongue in cheek, but he said basically, this is his workplace, right? His workplace is the college campus, and most of the instructors at BSU are not happy having concealed weapons in their workplace, because that's what they work. And his New York Times editorial said, so if your student pulls out a gun and is going to shoot me, do you want me to shoot them in the knee, in the arm, in the heart? Where would you like me, directed to parents, where do you want me to shoot them? So I'm kind of in conflict now. This is people's workplace, and yet they have to have concealed weapons there, but you can't do it at McDonald's.
And their liability issues, right, are especially for public institutions like the University of Idaho where I work. What is their liability if someone gets hurt? Do we have adequate security measures to detect? I don't think anybody's checking to see if people have permits if they're carrying. So I think that that there may be cause to re-examine some of the doors that have been recently opened in Idaho, at least to ensure that people are complying with the law and that people are safe.
Let me add a couple different things. One, we all accept the fact that we go through metal detectors from getting on an airplane. And we feel pretty safe when we get on an airplane. And, I mean, we may not like it, we may think it's intrusive, but everybody does it. We don't stop flying because you have to go through a metal detector. I don't think anybody would like the idea of going through a metal detector to come on campus. What I think a lot of people who believe in the right of self-defense and want to be able to protect themselves, I mean, what if an armed individual came in here with an AK-47 or some other firearm that had a lot of rounds? Do you know what the response time is to this room on campus? I mean, probably 6 minutes at the shortest. And how many people could that person kill in that amount of time? You have first responders. I was married to a cop and I'm dating a cop now, and I think they do the best they can. But they're not here when the criminal shows up. And the only thing that will stop someone like that is an armed victim, basically. Somebody who, is fairly competent with their firearm. And yes, people need to be educated. I'm all in favor of education. The more, the better. But I think the issue about, if you've got a government-owned or a government-run school, it's up to the legislature what they decide to do. If you have a private university, it's up to the private university as to what they want to do. And professors and students can elect to go where they want to go based on, they're not indentured servants to a particular university. I specifically choose restaurants that allow me to carry my concealed firearm in Arizona, because as we've seen from a lot of the things that happen, there's no guarantee that any place is really safe.
But we have a supermajority here in this state that is funded by NRA, so that they get money for passing NRA things. We had days of just 1 second. Please, we had the professors, we had everybody saying we don't want these in our classroom. and still.
We have a class that
Go ahead.
starts here in 4 minutes, so
Sorry.
I don't mean to cut you off, because ideally we'd have an event that kind of has a game time that we carry over with questions. So I do appreciate you coming with your questions. Everybody, I really appreciate you guys coming. We do have a class coming in, but I just want to give you guys one more hand.